Welcome to Landmark Chamber's webinar entitled Procurement Post-Brexit and Update. We're delighted to see so many of you joining the session today and hope you'll find the presentations and discussion to be useful and informative. Just by way of introduction, my name is James Neill and I'll be chairing the session today. With apologies, but Fiona Scolding, QC, is not able to be with us today to chair due to a court commitment. I'll be joined by my colleagues Tim Buley and Nick Grant, whom I'll formally introduce in a moment. Just to begin with a few housekeeping points to note. Firstly, your microphones are automatically muted so that you'll not need to adjust your local settings. We very much welcome questions throughout the session. Please submit them via text in the Q&A section, which may be found at the top or bottom of your screen. We'll endeavour to finish in time to answer as many questions as possible at the end of the presentations. This webinar is recorded, or will be recorded. You'll receive a link to the presentation recording shortly after the event concludes. Just finally, if your connection is lost at any point during the webinar, we invite you to rejoin the meeting by clicking on the original link once more. So just to begin by way of introducing our speakers, our first speaker today is Tim Buley, QC. Tim specialises in all areas of public and regulatory law, human rights, planning, environmental law and procurement law. Legal 500 describes him as, and I quote, clearly one of the most talented public lawyers of his generation of rising sort. So we're delighted to have him today to speak on the current position in terms of public procurement regulation in the UK, and in particular the status of retained EU law in procurement law. Our second speaker is Nick Grant, who is going to discuss the Trade and Cooperation Agreement and how it affects procurement. Nick is one of our more junior members. He joined Chambers in 2018 and maintains a practice in all Chambers' core areas: property planning, environmental and public law. He's an up-and-coming member of our procurement team, has already worked on a number of procurement matters, both advisory and litigious, at both authority and central government level in the last 18 months. So I'll now hand you over to Tim to begin our first presentation. Thank you.
So my topic is retained EU law in procurement law, UK procurement law. Obviously, the context for all of that, for that issue arising, is that in case anyone hasn't noticed, we've now completed Brexit. Brexit is done. We left the EU in the beginning of 2020, and we finished the transitional implementation period at the end of the year, 11 p.m. on the 31st of December. And that means that the UK is no longer subject to the EU treaties, of which we were part for however many decades. But we have signed up to a number of separate international treaties with the EU, including, most importantly, although neither really are the topic of this talk, the withdrawal agreement at the end of 2019, and at the 11th of that hour in last year, the Trade and Cooperation Agreement. You're going to be hearing something about those from other speakers. But UK procurement law, as it's existed certainly for a number of decades, was derived almost exclusively, if not exclusively, from EU law. On the other hand, the treaties, we're no longer subject to the treaties. European law, we're no longer directly subject to European law, and the European Communities Act 1972, which was the channel by which UK law gave effect to EU law, has been repealed. So the question is, what's the position for you for procurement law? How does all of that pre-existing body of law, does that pre-existing body of law continue, and if so, what's the mechanism for that? And in broad terms, that breaks down into two issues which I'll address. The first is probably the more interesting one in a way, although the less practical importance, but I think in some ways maybe quite practically important, is just the basic legal basis for procurement law to continue to exist in the UK as retained EU law. What's the legal framework for that? And secondly, the more nitty-gritty issue, what are the practical changes which have arisen as a result of Brexit so far, subject to the TCA, which I think Nick's going to talk about. So that's the agenda. So what is retained EU law and how does it arise? So, as I said, prior to Brexit, EU law largely given effect in domestic law via Section 2 in particular of the European Communities Act 1972, and that was certainly true for the procurement directives. And the 2018, the EU Withdrawal Act 2018, the 2018 Act repeals the European Communities Act. But critically, it provides for the retention of most, very nearly all actually subject to subsequent primary legislation, pre-existing EU law, and it does that through one of a number of different routes, 3 different routes. First of all, these are the channels via which pre-existing law continues to have effect. So Section 2, first of all, is EU-derived legislation. So any legislation, secondary or primary actually, which was passed in the UK so as to give effect for one reason or other to EU law will fall within Section 2. And although it's not really that important for procurement specifically, it's noteworthy that includes primary legislation as well as secondary legislation. And that's important because it means the government can amend primary legislation via Section 8, which I'll touch on in a moment. Secondly, then Section 3, directly effective EU law. And thirdly, Section 4, various miscellaneous things, but the 2 most important ones probably certain treaty rights, and then also directly effective EU directives. Now, there are interesting things to say about both of those, but they're perhaps a topic for another day. But note, because it might be of interest to those of you who are procurement lawyers, often overlaps with state aid issues, that Section 4 would be the route by which state aid rights continue to have effect in EU law, but for some other measures the government has passed. And EU law, the EU law we're concerned with is EU law as it stood on IP completion day at the end of 31st of December. It should say 2020 there. Apologies, not 2021. That hasn't happened yet. Okay. Now, that being the basic framework, the other thing that's very important are the provisions relating to the interpretation of that body of law. And Section 6 of the 2018 Act deals with the interpretation of retained EU law. Section 6.3 provides that a question as to the validity, meaning or effect of any EU law is to be decided in accordance with 2 things. First of all, in accordance with retained EU case law, and secondly, in accordance with any retained general principles of EU law, and we're told what those things are. So retained EU case law means CJ EU or domestic case law which relates to anything to which Section 2, 3 or 4 applies. Just think about what that means. So we're looking for case law which has been decided prior to IP completion day, prior to the end of last year, which relates to one of those 3 main channels. So in other words, not any old EU case law, but it's got to relate to something which is already retained EU law under one of the 3 channels that I've already indicated. And secondly, retain general principles of EU law, or principles which must, again, they're EU principles of EU law, but insofar as they relate to one of those 3 channels, sections 2, 3 or 4. And then we're given a definition overall of retained EU law, means effectively one of those 5 things. So the Section 2 EU-derived domestic legislation, Section 3 directly effective EU law, Section 4 those other miscellaneous things like treaty rights, and then retained EU case law relating to those and retained general principles relating to those. Now, the other thing that's really important to be aware of in all of this is the way that Section 6 makes a distinction between different kinds of case law. So first of all, Section 6 says that you can, let's say you or the courts can have regard to, but not be bound by, have regard to CJ EU case law decided at any point. You can always consider CJ EU case law and consider what its implications are for the interpretation of a particular measure. But secondly, domestic courts are, other than the Supreme Court and now in certain circumstances the Court of Appeal, are bound by CJ EU case law decided prior to IP completion date. Of course, that's only EU case law which bears on the interpretation of some other bit of retained EU law. But those decisions of the CJE continue to be binding on UK courts. The Supreme Court can depart, but only when it would only on the same basis it would depart from one of its own decisions, and the Court of Appeal can now do so, which is a bit, frankly, a bit confusing. That was by way of secondary legislation. We can, if people want to ask about how it works, we can talk about it at the end. But for now, just overview, note it down. Okay, and so just pulling back from on this, what is retained EU law question, what you've then got are three, what I think, you'll see some analyses which will say there are 5 categories of retained EU law. I don't think that's wrong, but I think it's important to distinguish 2 different stages. So first of all, you've got your primary categories, EU, there's a section 2, section 3, section 4 that I've spoken about, and then the secondary categories are the case law and the principles, but only insofar as they bear on those primary categories, which is why I regard them as being secondary to the main bits of retained EU law. And as I say in the slide, primary categories are retained in their own right, secondary categories are retained only as relevant to the interpretation of the primary categories. And then for procurement law, which we'll come to relatively shortly, the most important categories in practice are going to be EU-derived domestic legislation, because that's most of our procurement law is in that category, and then the case law and principles as to how they're interpreted. Then the last sort of bit of this jigsaw in terms of the legal framework is Section 8 of the 2018 Act, which provides for the amendment of retained EU law. And you can always amend or indeed abolish by way of new primary legislation, of course. And if you want to effect major policy change, if the government wants to effect major policy change, that's the route it should go down. But separately, there's a power in Section 8 of the 2018 Act to amend retained EU law. Now, that's an incredibly broad power in many ways, and in other contexts, I don't think it's been controversial in procurement law. In other contexts, it's been controversial and gives the government very wide powers. But it is nevertheless limited in that it is done, the power to amend exists for a limited purpose, namely to Section 8.1, to prevent, remedy or mitigate a failure of retained EU law to operate effectively or any other deficiency in retained EU law. And when I've spoken about this topic, focusing more on the Act, I've often used procurement law as an example of a very pure example of how that will work. So let's just turn now to see how that plays out in the procurement law context. So, as you will be aware then, UK procurement law prior to Brexit was found in the EU directives, which were then given effect to via delegated legislation, particularly but not only the Public Contracts Regulation 2015. So there's a straightforward example of EU-derived domestic legislation. It was legislation passed under Section 2 of the European Communities Act to give effect to EU law in a particular area of procurement. And so, as I've just said, the PCA then provide a very pure example of retained EU law and why you need the power in Section 8 to amend it. Because if you think about trying to apply the procurement of the public contracts regs as they stood on 30th of December 2020 and trying to apply them today, it would simply be incoherent, because the basic requirement in the regulations was to commence that a contracting authority had to commence a tender process by publishing a notice in the OJEU. And of course, as from the end of the implementation period, the OJEU is simply no longer accessible to UK public bodies. And for example, the Commission is given various oversight powers which cease to have any meaning, because the Commission will not take any direct interest in that way in UK procurement law. Of course, it might do so via the TCA, which Nick will be talking about, but that's in a different context. So if you don't amend the legislation, if you don't do something to change those references, then the whole thing's going to become completely unworkable, even though the basic structure is in place. And so what you get then are changes made by the 2020 regulations. I'm sorry, I thought I'd given you a reference. I thought I'd given you a reference to the 2020 regs. I'll dig up the full name in a moment. But the regulations passed in 2020. They make detailed changes to the public contracts regulations, PCRs, but really only to give some very limited changes to procedure. And so the main change that's been made is that contracting authorities are no longer required, as I've just said, it wouldn't make any sense, no longer required to publish notices in the OJEU, but they're now required instead to publish on the new UK e-notification service, which is the finder tender service, the FTS. And that's the biggest change, frankly. Then there are a series of other similar sorts of changes. So the transferal of, all really for just tidying things up. So transfer of those supervisory powers of the EU Commission are now given to the Cabinet Office, replacing the European Single Procurement Document with the SPD. There's omission of provisions relating to cross-border procurement with EU member states, because of course that no longer makes sense, and deletion of a particular mandatory ground for exclusion from participation in procurement relating to fraud on the European Community itself. And then there are similar changes made, those are the changes to PCRs, but similar changes are made to the other main procurement regulation regimes. And you can see that those changes really are, in practical terms, largely procedural. They change the identity of this, of the journal, of the bodies that have oversight. But in practical terms, on a day-to-day basis, your procurement process works in much the same way. You just go about it by publishing in a different place and notifying different bodies and so forth. Sorry, and last slide. Don't know why we missed that. Is transitional arrangements are provided for in the schedule, and that deals with procurement exercises that are ongoing on IP completion day, or i.e. the publication has already occurred. Those procurement exercises will proceed in the same way. That's obviously going to be of limited duration, but the most important point to note about that is that this will matter perhaps most for framework agreements that have been entered into prior to IP completion day, because call-offs under those framework agreements will continue to be required to be done under the pre-existing rules. And in practical terms, that may become particularly important if, as we're about to hear, the UK now simplifies its procurement rules going forward, because it may be that public authorities will prefer to effectively bring those framework agreements to an end and start again with the simplified regime, rather than remain subject to those pre-existing rules for what may be long periods of time. Thank you very much. That's what I had to cover. I think I'm handing over now to Nick Grant to tell you about the Trade and Cooperation Agreement. Thank you.
Thanks, Tim. Excellent. Right. Thank you, everyone, for joining this today. In very broad terms, the UK and the EU are signatories to the World Trade Organization's Government Procurement Agreement. When the UK left the EU, it became a signatory to the GPA in its own right. The reason I'm flagging this is because, and we do like to give you value here at Landmark, to understand the Trade and Cooperation Agreement, you also have to understand the GPA, because in very broad terms, the way the Trade and Cooperation Agreement works with respect to procurement is to incorporate various specific provisions of the GPA between the UK and EU, and then add bits on top. So we'll pick up at Article 276 of the TCA, and this outlines the objectives of the procurement provisions. There are 2 points that come out of this. It's both the objective of the procurement provisions in the TCA, both to guarantee each party's suppliers access to increased opportunities, and to enhance the transparency of the procurement process. This is important, as it will, of course, should there be any disputes as to how either how these operates or how they're being used by the various parties. The objective provision here is going to be important, at least for the interpretation of that. So let's then pick up Art 277.1 refers to the first point I made, which is about this incorporation of the GPA. So 277.1 provides that provisions of the GPA specified in Section 8 of Annex 25 are hereby incorporated into this title. Annex 25 of the TCA lists, frankly, is in 2 parts. Part A lists, or Section A, I should say, lists these various GPA incorporative provisions, and Section B then, but we'll come back to where Section B comes in. There's quite a lot in the GPA that's incorporated by this section. I'm just going to highlight some key points because we don't have time to go into, frankly, everything today. The main one I want to highlight is Article 3 of the GPA, which deals with security and the general exception provisions. Now, this basically provides that nothing in the GPA prevents a party taking action or not disclosing something for the protection of essential security concerns, talking about the procurement of arms, ammo, or war materials, or, for example, for national defence purposes. That exception also, other than that broad arms and defence point, applies or allows parties, provided they're not doing so in an arbitrary and unjustifiable way, to enforce measures necessary to protect public morals, public order or safety, human, animal or plant life and health, intellectual property, or goods and services of those with disabilities, philanthropic institutions, or indeed prison labour. This is the second part of the GPA incorporated provisions. And once you get through all that, we then get to a distinction between covered procurement and procurement beyond covered procurement. And that's what I'd want to pick up now. So covered procurement effectively is what's set out in Article 2 of the GPA and then Section B of Annex 25 to the TCA. So Article 2's sort of the crux of the matter, and then Section B in Annex 25 is where we see the UK and EU adding bits on top. Article 2 of the GPA covers rather a lot of matters, the procurement for governmental purposes of, for example, goods or services or a combination thereof, over a certain value threshold, and provided, of course, there aren't, that it's not otherwise excluded. If you have 5 minutes and decide to turn up Article 2 of the GPA, it's going to cover a lot of matters that, frankly, those of us dealing with procurement are quite used to. Some of the exceptions outlined in that article include things like employment contracts, and it also includes, interestingly, acquisition or rental of land or other immovable property. We then get on to Section B, and Section B of Annex 25 takes this much broader. I've laid out some of the things on your slide. Utilities, for example, the kind of things that we're used to seeing covered by the utilities regs, hotel and restaurant services, food service services, beverage serving services, telecoms, real estate services, and other business services. I've outlined those sort of broadly, but they all have a CPC classification, and CPC, of course, means the Central Product Classifications that was prepared by the UN in 1991. Interestingly, what is explicitly excluded from this are human health services, administrative healthcare services, and the supply of nursing or medical personnel. So something that we at the moment be recognised as being covered by, or I say at the moment, we 7 months ago would recognise as being covered by the light touch regime. If what you're trying to procure does fall within covered procurement, Chapter 2 of the TCA then includes specific procurement provisions and rules on top of a lot of those that are incorporated in Article 20 by the GPA, from the GPA, sorry. So Article 278 talks about using electronic means to the widest extent possible. That means we're talking about publication of notices and documentation, submission of requests to participate, and the electronic processing of invoices. Article 279, electronic publication of procurement notices, that'll come as no surprise. Again, this is all sort of transparency stuff as well. Article 280 is clearly aimed at making sure you can't reduce competitive advantage, or the UK can't reduce the EU's competitive advantages and vice versa by drowning tenderers in paperwork. It provides that basically procuring entities cannot require suppliers to submit all or any part of any supporting evidence showing that they're not in one of the situations in which they may be excluded and that they fulfill the conditions of participation. There is a catch-all proviso to that, which is if it's necessary to ensure the proper conduct of the competition, of the procurement competition, then they can do so. Article 281 provides that where, if it's a condition of participation that a supplier has prior experience, a party, whether us or the EU, cannot require that experience be in its own territory. So we can't require them to have previously undertaken work in the UK, and the EU in the EU itself or member states therein. Article 283 provides that if a party is using selective tendering, that is any process in which qualified suppliers are invited to submit a tender, invitations to tender have to go to a number of suppliers that is sufficient to ensure genuine competition without affecting the operational efficiency of the procurement system. Art 284 provides that if a procuring entity receives a tender with an abnormally low price, it can verify with the supplier whether the price takes into account any grant of subsidies, and it can then take that into account. Article 285 requires parties to ensure that its procuring entities may, so only may, not must, take into account environmental, labour and social considerations throughout the procurement process, provided they're compatible with previous rules and procedures as indicated. And they must be indicated in the notice of intended procurement or tender document. Now, just pausing for a second on this, what it does mean is we'll probably still see domestic courts grappling with the extent to which such considerations can be taken into account in the tender process. One might argue, and I think it's probably right, that this does open up interesting scope for divergence between the UK and EU regimes. But it's important to be aware that amongst the many, many other provisions in the TCA, there's a general level playing field provision in Title 11. Now that doesn't require full regulatory alignment, but the parties have agreed to treat the current shared regulations on employment, on workers' rights, social protection, environmental standards, tax transparency and state aid as a common baseline. And the level playing field provisions require that they then both agree to observe international standards in treaties in the relevant areas. So, for example, OECD treaties, and there is a commitment by the UK of non-regression from those existing standards, particularly in labour, social and environmental and climate standards, where that regression, so it's not total non-regression, but they can't do it where such regression would have the effect of undermining competition or investment as between the UK and the EU. If there is a breach of these, then the parties can appoint a panel of experts to write a report. That report is not going to be binding, or they can take what is known as rebalancing measures for as long as required. Staying with covered procurement, Article 286 then governs the domestic review procedures. As you can see, it incorporates one of the articles of the GPA, and that requires setting up an impartial administrative authority. The TCA then expands on this by requiring that the members are impartial and independent, that they are not dismissed against their will while in office, unless required by the provisions governing the designated authority, i.e. the overall authority that's been set up, and that the president or at least one other member of the league has legal and professional qualifications equivalent to those necessary for judges, lawyers, or other legal experts. It also requires that each party adopt or maintain rapid interim measures to preserve the supplier's opportunity to participate in procurement. Now, this includes resulting in the suspension of the process, or if the contract's been awarded by then, suspending that contract. These may, of course, take overriding adverse consequences, including the public interest, into account. If an interested party has submitted a challenge, each party shall ensure in principle that a procuring entity shall not procure the contract until the authority has made its decision or recommendation. And again, though there is the carve-out, it may provide a contract can be concluded in unavoidable and duly justified circumstances. So that's a very brief overview of covered procurement. We then get into beyond covered procurement. Now, this is frankly written in fairly obfuscatory language if you ever turn up the provision, but it basically means that outside of covered procurement, the UK must not have in place measures which result in EU suppliers being treated less favourably than the most favourable treatment granted to UK suppliers, and the UK must not have in place measures resulting in EU suppliers who are established in the UK from receiving less favourable treatment than the treatment accorded to UK suppliers. Chapter 4 then includes some mopping up provisions, and it allows a party to modify or rectify the market access commitments contained in Section B of Annex 25. A rectification here seems to be a kind of technical modification, not kind of rectification as common lawyers are used to. So we're talking about changing the name of a procuring entity, or if two entities merge or one entity is divided, etc. A modification seems to be anything else. If there is an objection to that, then the parties must try and sort it by negotiation. If they can't, then they have to refer it to the dispute settlement provisions of the treaty. That's it from me. I appreciate it's been a fairly swift canter through what is in fact a fairly complex treaty, but I'm now going to hand over to James to talk about transforming public procurement in the government's green paper.
Thank you, Nick. So I'm going to be talking to you about the detailed contents of the green paper entitled Transforming Public Procurement. I'll set out the timeline in a moment so that you all understand where things are at present. But I think just to begin with and to frame the discussion of the contents of the green paper, I think it'd be useful just if I were to read out what exactly is said in the executive summary at the front of the green paper. And this states what the government's goal is. It states that the government's goal is to speed up and simplify our procurement processes, place value for money at their heart, and unleash opportunities for small businesses, charities, and social enterprises to innovate in public service delivery. The current regime for awarding public contracts are too restrictive, with too much red tape for buyers and suppliers alike, which results in attention being focused on the wrong activities rather than value and transparency. So that's what is said at the beginning of the green paper. It's important to note at the outset 4 particular themes that are referred to in that summary, and which one can trace throughout the 7 chapters of the 81 pages of the green paper. And those, first and foremost, is the emphasis on speeding up and simplification. So that's the first thread that seems to run through the green paper proposals. The second theme or thread that runs through the green paper is the emphasis on making it easier for small businesses and charities, social enterprises, etc., to participate and to take advantage of opportunities to bid for public contracts. The third theme is which slightly cuts across those 2 initial, certainly the initial requirement for speeding up and simplicity, is the emphasis on transparency. And what I'm going to try and show you in the course of today's presentation is where and extract out of the green paper some of the more tangible proposals that are quite likely, or at least seem quite likely, to come forward or to be proposed in legislation as early as later this year. And so just looking at that timeline, so where are we now? Well, the consultation on green paper ran from the 15th of December 2020 to the 11th of March 2021. And in the Queen's speech, so it's now closed, and we're waiting for the government's response to that consultation. The Queen's speech on the 15th of May indicated that a procurement bill is now going to come forward containing laws to simplify procurement. And there have been certain indications, and that no doubt many of you on the seminar may have heard these informally, that a bill may be introduced as early as September 2021. So changes are afoot, and it seems are quite imminent. So just turning to what are some of the more tangible proposals that one can extract from the green paper. Well, first of all, the government's proposing a new set of procurement principles. Now, these are going to be broadly based on the principles set out as they must be set out in the WTA government GPA, which you've heard Nick speak a little bit about. I've set out on the slide what those principles are. Now, some of those will be familiar to us all: transparency, fair treatment, and non-discrimination. There are a couple that have been included that won't be familiar to us as procurement practitioners, notably the public good, reference to public good, and reference to integrity. And in terms of the public good, the green paper states that what that principle means is that procurement should support the delivery of strategic national priorities, including economic, social, ethical, environmental, and public safety. So it seems that as scope for new flexibility in our procurement regime has now been afforded by us leaving the EU, what can be detected in the Green Paper is the government beginning to introduce into the procurement rules, or proposing to introduce in procurement rules, certain principles that don't go just to the management of the procurement competition, of a particular procurement competition, but are also there to advance what central government policy and agenda. And that's going to slightly cut across against the need to simplify procurement procedures, because you'll immediately have a tension between the government trying to introduce through policy certain imperatives that it expects to see in public procurement, but at the same time trying to simplify procedures for contracting authorities carrying out those procurements. And how that tension will be resolved remains to be seen. But I just wanted to flag that up at this stage. In developing on that theme, i.e. the idea that the government is going to there's going to be increasing government intervention in the way contracting authorities actually carry out their procurements and carry out their procurement activity. The government has heralds in the Green Paper the idea of the introduction of something called the National Procurement Policy Statement. And I set out the extract from the Green Paper on this slide. It states that the government will separately set up plans to legislate to require contracting authorities to have regard to national priorities of strategic importance in public procurement. Now, just pausing there, that will, as public procurement becomes like any other public law regime, a set of regulatory controls governing the behaviour of public activities, it will be interesting to see how that requirement on contracting authorities will be enforced and what exactly the law will say. We've already seen in the last year the courts, through the challenges to the PPE and the sort of COVID contracts, beginning to expand the scope of judicial review into procurement decisions. And it's not really addressed in the Green Paper, but one can see that a further scope for third parties to begin to start to look at how the National Procurement Policy Statement is applied by contracting authorities, and potentially to bring challenges based on a non-adherence to that policy statement. So it'll be interesting to see how that pans out. But either way, this national policy statement is going to be very important for contracting authorities to adhere to. In line with this idea that this theme of increasing intervention by central government, one can also see in the Green Paper the proposal for the establishment of a new central oversight unit with powers of intervention, including improvement notices and, significantly, for local authorities, spending controls. So the Green Paper refers to the pre-existing PPRS scheme, the Public Procurement Review Scheme, that's fairly toothless, that's managed by the Cabinet Office. And it seems that there's going to be a new unit with greater teeth to enforce. It seems at a systemic level certain standards, and to ensure that contracting authorities, in terms of their procurement behaviour, measure up to whatever set out either in national policy or in guidance. So that will be a completely new body, and it'll be very interesting to see how the legislation is crafted regarding its powers. But there's no further detail on exactly what those will be. So moving on from the National Procurement Policy Statement and the establishment of central body, looking now in a little bit more detail about what the actual regulatory framework will look like. Well, first of all, the current set of PCRs, utility contract regs, concession contract regs, defence and security public contract regulations are all going to be consolidated, or at least proposed to consolidate them into one set of regulations with sector-specific sections. Now, one can discuss the pros and cons of that, but that may add to a degree of simplicity, or it may just simply import into that consolidation some of the pre-existing complexities. But perhaps more substantively, what's proposed is the replacement of the current 7 procurement procedures that can be seen in the PCRs with 3 new procedures. Those are described as a new competitive flexible procedure, an open procedure, and a limited tendering procedure. Now, this is important because this is going to set the shape of how procurement competitions will be run in the future. The new competitive flexible procedure, it seems, is going to be broadly similar to the light touch regime that's currently available to certain contracts, health and social services contracts in particular, under the current PCRs. So the straitjacketed approach in the PCRs will be lifted. There will be an open procedure, but at the moment, no restricted procedure is proposed. Then there will be the limited tendering procedure. Now, that is essentially the same as the negotiated procedure without prior competition. So the not necessarily single source awards, but that is a sort of renaming that particular process, that particular procedure. And that broadly, it seems, the PLA response, the Procurement Lawyers Association response to this seems to be broadly supportive of that simplification, bar the removal of the restricted procedure. And the PLA, for example, has suggested that should be reintroduced. So that's the way the competitions are proposed to be run, and the regulatory framework. And just moving now to a little bit more detail, looking at how award selection and exclusion rules will be applied. The proposal is that the requirement to select the most economically advantageous tender, so-called MEET criteria, should be changed to the most advantageous tender. Now, that seems to be a matter of semantics more than substance, not least because the most advantageous tender principle isn't really recognised in the GPA. That's more aligned with the current criteria of most economically advantageous tender. But that seems to be the reason for the government removing the words economically advantageous and just leaving it at advantageous. It seems is to try to shift the scope of procurement and the focus of procurement not just to price, but to look more at other factors, including social value, quality, etc. Of some significance is that there will be greater opportunities to break the link with the subject matter between the procurement and the subject matter of the contract. Apologies, I shouldn't say contractor. And there's going to be when designing the award and selection award criteria, and there's going to be greater scope to take into account poor prior performance of contractors, which I think will be broadly welcomed by contracting authorities. There will also be additions to the mandatory exclusion grounds. There's going to be some changes in terms of references to fraud, non-disclosure of beneficial ownership, and tax evasion. There will also be greater flexibility in terms of the way in which contracting authorities can require bidders to submit information to verify financial standing, etc. And that will move away from the very circumscribed amount of information that can be required under the PCRs. And of some practical importance is the proposal of the establishment of a new central debarment list. That will be, it seems, run by the central body or unit that I referred to at the start. And the central debarment list it's proposed will be used for all the mandatory exclusions, and could be continue to be developed and improved to also include suppliers that have committed actions that fall within some of the discretionary exclusion grounds. And so the purpose of that is, it seems, to help contracting authorities identify organisations who should be excluded from public procurement, and rather than having to do the investigation themselves or to rely on external sources, it's meant to be a way of establishing that information or collecting that information in one place. There are some greater flexibilities introduced in terms of the way dynamic purchasing systems and frameworks are going to be used. It's proposed that there will be a dynamic purchasing system plus, as it's called in the green paper, and essentially the DPS process will be available to all types of procurement, not just goods and services generally available on the market. In terms of frameworks, the green paper proposes longer maximum terms for frameworks. For closed frameworks, 4 years, and for frameworks that can be joined at certain set points, an increase of the duration of frameworks to 8 years. And these particular proposals seem to be sensible, and the response, certainly by the Procurement Lawyers Association I've been involved in, seems to support those, and if anything, should think that the framework agreement duration could be even longer. The transparency requirements or the greater emphasis on transparency that's proposed. Now, these are set out in Chapter 6 of the Green Paper, and they're important because they work in many ways hand in glove with the way the government's going to change the remedies regime, which I'm going to touch on in the following slide. I've set out what the text of the Green Paper and what it says in terms of embedding transparency. That states that contracting authorities will be required to disclose procurement and contracting data as soon as practically possible, and significantly increase transparency in the public procurement regime. Now, in essence, the emphasis in the Green Paper is that in real time, as a contracting authority works through its commercial life cycle of its procurement, it should be disclosing information at certain stages in a more standardized and set way. And that's going to be really brought in through compliance with a legal duty now to comply with the Open Contracting Data Standard. Now, the OCDS, as it's called, it's been around for a while anyway, but that's described, for those of you who aren't aware of what it is, that's described as a free, non-proprietary open data standard for public contracting authorities, and it's implemented by 30 governments globally. And it describes how to publish data and documents at all stages of the contracting process. And set out on page 53 of the Green Paper is a list of the revised set of contract notices that align with that data standard. Now, the reason this is all important is because when it comes to the award notice and setting out and complying with the OCDS there, one would hope that when these reforms are brought in, the government will standardise the way in which evaluation data is provided, scoring, etc., of a bid, or so a bidder can understand very quickly what scores it's received and against which criteria, and avoid some of the current confusion or the current uncertainty at the end of the bid process, where a disappointed bidder tries to get that information out of the contracting authority, and it sometimes comes out in drips and drabs. Now, the reason this is going to bring in quite fundamental changes in the remedies regime is because it's proposed that the debrief letters post-award, which include the analysis in the PCRs of the strength and relative advantages of the winning bidder, may no longer be mandatory in light of the ongoing information and standardised information being provided at contract award. It's not quite clear how much further detail will be provided, but it does seem that one can discern in these proposals that there should be more information coming out sooner from the contracting authorities to make it easier for bidders at the end of the process to understand why it is, for example, they haven't been awarded a contract. And finally, in terms of transparency, a system of contract amendment notices were going to be required in the majority of contract amendments. And the idea is that's going to be a sort of more of a default mechanism to issue a contract amendment notice, which will trigger a standstill, etc. And that's, it seems, is proposed to replace the current voluntary transparency notice, or what's previously referred to as the BEAT system. So that's the greater drive towards transparency. Now, moving on to how that plays out when it comes to remedies, and this is where I'll end the presentation, because it's here that if there's one tangible and fairly radical proposal that's proposed in terms of the public procurement regime, is to be found in Chapter 7 when discussing the remedies regime. The thrust of Chapter 7 is that the government wishes to place greater emphasis on the availability of pre-contractual remedies and quicker trials, and downplay the importance, and we'll see how it's going to do that, downplay the importance of damages. Now, firstly, it's proposing, in terms of supporting and providing greater emphasis for pre-contractual remedies, various tweaks to the procedure in the Technology Construction Court are proposed. And for example, there may well be mandatory initial disclosure requirements, etc. Most of those tweaks are welcome, and I won't go into all of them because some of them are very detailed and of any interest to procurement litigators. But the most significant proposal, and the one that really stands out in Chapter 7, is the proposal to cap the level of damages available to aggrieved bidders to legal fees and 1.5 times bid costs. Now that is a huge change if it was to come in, and it's justified because the idea is, well, it should be much easier to get a pre-contractual remedy with quicker trial, and therefore damages shouldn't be so important. This is vociferously, perhaps unsurprisingly, this proposal has been vociferously disputed by the Procurement Lawyers Association response, is vociferously resisting this particular proposal. I won't go into the reasons why, but one should read, if you're interested, read the PLA's response to this. But the cap on the level of damages works hand in hand, and it's quite hard to see how it will pan out, because it's still the proposals are still fairly inchoate in Chapter 7. But the proposal to cap the level of damages has to be seen in the context of how the test to lift automatic suspensions may be changed. So the government, at the same time as saying we're going to cap the level of damages to 1.5 times bid cost, is suggesting an amendment to the American side of the test to lift automatic suspensions, and is saying, and I quote, it should no longer be, the American side of the test should no longer be based on the automatic suspension should no longer be based on the American side of the test, but should be a more appropriate procurement-specific test. We would aim for this test to balance public interest, urgency, the upholding of the regulations, and the impact on the winning bidder against the right for the claimant to be able to participate in the contract and the alternative available remedies. Now that's all a bit vague and blurry, but there is the Procurement Lawyers Association, in response to this, has made it very clear that the test should effectively, or the default option should be to maintain the automatic suspension, unless there are exceptional circumstances in the public interest. So to swing the balance back towards the bidder in terms of making it easier to get the automatic suspension. Now it remains to be seen how or whether the government will respond to positively to that proposal. But at the moment, the proposal to cap the level of damages at the same time as not making it easier to get an automatic suspension would, it seems, to be fairly problematic and create all sorts of problems, which I don't have time to go into now. Finally, there is a proposal to transfer a set of procurement challenges, and it's not defined how or what the criteria would be for those, to a tribunals-based system, which might, for example, deal with what's known as in-flight challenges. And as I said on this slide, the thresholds aren't clear. But that could be a positive development if it allows greater access, for example, to smaller companies to bring challenges on for lower value procurements. There's also reference in the Green Paper to independent contracting authority review, and it's not clear if this is intended to be by the contracting authority itself or by an external body. It seems, reading Chapter 7, it seems to be proposed that it should be by the contracting authority itself. Not quite clear how that would add much to what the contracting authority should be doing anyway, in the event that its contract award decisions are challenged by an agreed bidder in correspondence. So I see the time now. I've finished 1 minute before midday. I'm just having a look now. That concludes my presentation. And now switching back to my role as chair, I'll be happy to take any questions. And I'm just having a look now if we've received any on the chat. I haven't received any yet, but if one does have any questions, or if anyone would like to discuss anything arising in this presentation, please don't hesitate to get in touch with any of our speakers. I'll just give everyone another 10 seconds or so to see if there are any questions. There is one question that has arisen, which is the way in which the proposed dispute resolution provisions are set out in the GPA, as opposed to what's set out in the Green Paper. I wonder if Nick might be best placed to deal with that. So Nick, yes, could you give us an outline of what those provisions are in the GPA?
Sure. I mean, I'm thinking, looking at the question that is asking about the resolution of if there's an issue between the UK and the EU. I've already touched on the dispute resolution provisions that the GPA requires each party to incorporate. Basically, they're relatively unsurprising provisions. So it requires that and resolve matters first by consultation and negotiation, and there are set time limits for that. If that doesn't work, then either party can request the establishment of an arbitration tribunal. Each party has an obligation to put together a sub-list of its preferred arbitrators. And for anyone thinking of applying, I just, in fact, checked online during James's talk, and the applications are open for those who wish to be on the UK's list. If a party fails to appoint a arbitrator from its own sub-list, then the chairperson of the partnership council from the complaining party shall select one, and they do it by lot. The parties then agree a chairperson, and again, if that can't be agreed, then the chairperson of the partnership council being something set up by the treaty, selects by lot, again from a sub-list. The tribunal renders its decision, and if it finds a breach, then of course the party in breach must comply immediately, and if it's not possible to comply immediately within a reasonable period of time, any issues of compliance may be referred back to the tribunal. And there's also interestingly a list of temporary remedies that can be imposed while a party is non-compliant. This includes compensation, but also includes the innocent party, for want of a better word, being able to suspend its own obligations, subject to some limited exceptions, whilst the other party is non-compliant. There are also special provisions for certain remedial measures and rebalancing if required. What's also interesting, I think, given, as I've outlined, the sort of two treaty state, the fact that we've got the GPA, with which the UK and EU are both signatories, and the TCA, is basically you pick your forum. So there is express provision in the TCA saying if it's a breach of both, then the complaining party can pick under which agreement it wants to pursue the claim, but once it's done it under one, it can't pick and do it again under another one, under the other one, I should say. So that's largely it in outline, James. I could go into more detail, but that'd be an entire presentation in itself.
Excellent, thank you very much, Nick. I'm just conscious of time now, and I know Tim needs to leave us now. There are a couple of other questions that have arisen, which I don't think we've got time for. But what I will suggest is that whoever the questions are best answered by, I will just run those past the speakers, and we'll perhaps get in touch directly if that's okay. So I think that will save time. But I think that really means we better wrap it up now. Thank you very much to Nick and Tim for your talks and very informative presentations. Thank you very much for everyone attending. If I could just say that there will be a follow-up to this seminar to discuss changes to state aid. The details are on our website, but this is the sort of second part of our procurement and state aid, our procurement and state aid series, and that will be on Friday, the 2nd of July at the same time. So we look forward to see as many of you there on that second seminar as possible. Thank you very much indeed.
Thanks.